Good morning, Joe. Sorry, off to a late start. We got off on a few tangents. Fun tangents. Everybody, I'm with Joe Haytas, my very good friend, attorney, fellow colleague in the parole hearing. I don't want to call it a fight. It's a journey. Let's call it a
Yes.
journey.
There you go.
I'm Elizabeth Comeau, your host. Today, Joe had a great topic that we should go over again: waivers, postponement stipulations, and the differences, why they're necessary, what's going on. A lot of people say postponements for waivers. Some people say waivers for stipulations. Some people don't know when, how they work, especially family members. When our clients call you and say, oh, my attorney says, or is it suggesting that I waive to do this, this, and this, and you say no. And a lot of times that's due to just a lack of knowledge in what the process entails. I want to first and foremost say that our job for your loved one is to find a way to get them out of prison the soonest as soon as possible. Our job is not to get them to a parole hearing as soon as possible. Is as a philosophy, okay? So our philosophy is, how can I get you out that gate as soon as possible? And so some people misapprehend that getting me to the hearing is getting me to the gate as soon as possible. And that's not always true. And so it's kind of a matrix. I don't know if that's the best word, but I do a lot of flow charting with my clients about what's the best option. Sometimes they listen, sometimes they don't. Sometimes I can't always predict the future either. And so the matrix is sort of a fluid thing. We do a lot of ifs, contingents, and things like that. But why don't we start first, Joe, with postponements, which are the most misunderstood I don't know, vehicle for putting off a hearing.
Yes. And also there's the verbiage, because it all comes down to semantics. If somebody gets a waiver, they say, oh yeah, I'm postponing the hearing for a year or 2 years.
Right.
So the legal meaning of postponement is that you're putting the hearing off basically for the shortest time possible until you can get back on the calendar. But you can only postpone for reasons that have to do with exigent circumstances, meaning you just learned something, then you have to put the postponement in as soon as possible. You just learned something like, hey, I just discovered my documents are lost, or we just discovered the commissioner is sick and can't make it to the hearing, or things like that, things that pop up and are
and a
of
lot
the
of
moment.
times those postponements aren't done by us or requested by us. They're requested, like you're saying about the commissioner being sick. They'll be
Exactly.
requested, or not even requested, but they'll be implemented by the Board of Parole Hearings in Sacramento, and you'll just get a notice going, this hearing's being postponed.
Yes, and you'll be back on the calendar of that institution as soon as possible.
As soon as possible. And as soon as possible means usually no less than 6 months, because they've got to recontact victims, recontact the district attorneys, find another attorney to take the case. The attorney is supposed to have be able to meet with them at least 150 days before the hearing, I think is the rule, and that a series of meetings thereafter. And so that all comes into play. But
Exactly. Sending out the notices to everybody.
Everything has to be totally redone,
Yes.
squeezed into the calendar, and all of that, which is very tricky for the Sacramento to do.
And like you say, it takes a minimum of 6 months.
Minimum. Now, that's from their end of things. From our end of things, it's very hard to ask the board on behalf of your loved one for a postponement. We're just talking postponement, because a postponement is not like a waiver, which if you do it 45 days before with any reasonable reason, it's going to be granted. A postponement is not like that. And it's,
Mhm.
you ask for 6, 7, 8, 9, 10, or 11 months. There's only very, very specific reasons. And those reasons, I'm telling you, most mine are denied 50% of the time. Now, if my
Yes.
client says, I want you to ask for a postponement, and he just wants me to do it, and I tell him I don't think it'll be granted, I don't know how I can do it, I will do that under McCoy v. Louisiana, the United States Supreme Court case. It tells me that my client has the ultimate authority for
Mhm.
almost everything. If he says, I want you to try for this postponement, then it's my job to see if I can fit it into some kind of reason. It has to be something that would affect the outcome of the hearing potentially, or your rights at the hearing. So I just got a 115 for
Mhm.
this cell phone. It's not mine. I haven't had the hearing yet. I'm planning to litigate. There's cameras. I think I'm going to be found not guilty. It's very important for that to be taken care of before your
Mhm.
hearing, because the commissioners, even though there shouldn't, they're probably going to use that against you. So it's probably better for you to get that cleared up. That typically takes 6 months, but it can take up to 7, 8, 9, 10, or 11 months.
Yes.
So that's something that could be, I've had the pending RVRs usually granted. I've had pending litigation for resentencing hearings under all those new bills.
No.
I think I've been granted once, and I don't know, I think the
Right.
guy that does them was just,
In other
I
words,
don't
if
know.
right, if you're going out, if your client's going out for resentencing, yeah, that's not a reason for a postponement because you know about it, and a waiver is more appropriate, at least in being granted for what you're asking for.
A waiver is easier. I mean, you'll argue, say, well, I don't want to give testimony at my parole hearing because that can be used against me at my 1473 hearing. And for whatever reason, Sacramento feels it's more related to a waiver. So
Yes,
waivers
correct.
are 1, 2, 3, 4, or 5 years,
Mhm.
as long as you do them before 45 days, any good reason, any good reason. I have had them rejected for when clients put goofy reasons down. It's just goofy. The Board of Parole Hearings is prejudiced against me and is never going to grant parole. That will be denied.
I would
That will
say
be,
that's a goofy reason. That's a good description of that.
I mean,
No.
that's how they feel, and
Mhm.
that's fine. I've had them come in. They've told me to sign it. My client, they said, I don't, I said, well, maybe we should put a different reason. I want to put that one in. I go,
Yeah.
okay, we'll put that one in, but I need to let you know that, one, it's probably going to be denied. Two, we have to resubmit it with, they want to put that in. Usually we're dealing with mentally unstable people or other issues, and that's
Sure.
fine. But
Yeah.
postponements in general get mixed up with waivers,
Mhm.
and so they're more logistical in nature. Documents are, it used to be like the transitional housing program that I wanted to get into has recently shut down, didn't get me a letter in time. Even that is just not going to work because there's so many other transitional housing places available, and quite frankly, um, you don't need it anymore. They're saying that you don't need it. And
Yeah.
so
And that is very interesting because throughout all this journey, if you will, there's always, they want to see that you're planning for the future. And one of those ways is to get transitional housing in place with an acceptance.
remember that, Joe? We got that training, and you and
Yeah,
I were like,
exactly.
"Wow, okay, you don't need transitional housing anymore." But
Where did that come from? Yeah.
But I am not going to counsel my clients not to plan for all of that. I'm just not. I just don't trust the commissioners, all of
No.
them, to say, "Oh, okay, that's fine. You don't have transitional housing." It's just another reason to either aggravate risk, or I don't want to give them any reason if I don't have to. And if the person is capable of writing to a transitional home or two, I just encourage it. It's better to have a well thought out plan
Yeah.
about, what
And
you're doing.
excuse me, what about the structured decision-making framework? The parole plans for parole is part
That's
of
right.
that. So, yeah, how does that nullify, transitional housing? And you know what? Also, you look at some of the various transitional houses. Um, some of them, like the more noticeable ones, like say Amity and Francisco Homes, they're very focused on sending out letters of acceptance, and there
Right.
must be a reason for that.
Right. And they send nice letters. I mean,
Yeah.
Francisco Holmes and the other one, Prep,
Hmm.
she sends a personalized letter on your behalf or your
Right.
loved one's behalf. So you might as well. She puts a little thing about the journey to rehabilitation and how, and then she has a little background of the guy that she puts in there. So it doubles as a
Yeah.
support letter as well. But sorry to
Hmm.
get off track on the
No, that's okay.
transitional housing, but
Hmm.
so postponements are tricky. I don't have a lot of examples for when postponements would be approved
I have an
by
example.
the attorney on behalf of the client, but Joe's got something.
You know what? And this was from a transcript that I read recently for somebody I represented, and they had gone to a hearing previously with an attorney representing them by the name of Elizabeth Comeau.
Uh-oh.
And in the middle of, well, at the beginning of the hearing, you argued that the documents he had submitted were not available, were not in the 10-day program, or I'm sorry, 10-day file. And I'm all excited here. They weren't
That's
in the
okay.
10-day file. So actually, the hearing wasn't postponed. It was, now that I think about it, it was continued to the
Continue.
next available date.
So
And
I think sorry, didn't mention continuances. Continuances are after the hearing has started and
mhm,
your client has sworn to tell the truth under penalty of perjury. Once that happens, it only can be the hearing has to be continued.
yes. And you know
So
what? It was
mhm,
continued for that, and plus the BPH wanted to do an investigation into this person's past uh, security threat group, uh, uh, you know, conduct, if you will.
I think I remember that one. I think it was in person, and I think there was hundreds of pages, and the commissioners was like, "We're not gonna read this." And
Okay.
actually, I got upset. I got upset, and I told not only PJW, but I told, Vanessa as well. I said, "You can't do that because Jennifer Schaefer said she removed the limitation, the page limitation, and to
Hmm.
just have a blanket rule that I'm not gonna read any more documents that you give me on the day of your hearing, regardless of how many pages it is." And I do appreciate and I do empathize for that, but this isn't about the commissioner anyway, and our clients are just I think with that client too, he had made efforts to send them in a month before he
Yeah,
had received the letter saying, "We have
exactly.
them." They got lost. Before that hearing too, I was on the phone because I was in person. I was on the phone. I'm not gonna say we're not gonna say the client's name. I just
No.
I know the one that you're talking about. And
Yeah.
I was on the phone in the prison trying to find I'd have you because I have no phone numbers. I have no phone. I had nothing. So I had to ask the officers to kind of snoop through to see if they could find any kind of number or something because I didn't even know my own secretary's cell phone number. Trying to call to Sacramento to
Oh,
chase
because you
these
didn't have your
down.
cell phone because you're in the institution.
No
I
cell
got it.
phone. I couldn't
Yeah.
remedy it. And this document issue, by the way, has been a nightmare. And I'm going back to having my clients send me the documents for me to email because sometimes they get them and scan them up there and sometimes they don't. And this
Mhm.
whole commissioner, I'm refusing to read documents. And they scolded us at that hearing so inappropriately as
What?
well. Yeah, well, if you read the transcript, you'll see
I
they scolded
I
my
did.
client and me for,
Hmm.
how dare you do this at the last minute? And I had to say, this was not done at the last minute. He sent them, pursuant to instructions, 30 days before the hearing and received a letter saying that they had been received and they were not processed by Sacramento. This is not the fault of the client. Now, that client to post needed to
Be
put his
continued.
ear it needed to be continued,
Yeah.
waived, postponed, put
Hmm.
off into the future.
Yes.
I guess what we're trying to say is a couple of tangents that we've gone off on is putting your hearing off in the future happens via postponements, continuances, waivers, or stipulations, but each one has a different sort of ground or basis for doing it.
Yes.
And so we've
Hmm.
covered continuances, we've covered postponements, and lightly touched on waivers. How about everything covered on postponements, Joe, or would you like to move to waivers?
Well, just to summarize, postponements would be for like exigent circumstances, things that come up, and it has to be put in right away. And they're usually things that are beyond our control.
I like
So,
that.
like
Beyond
emergencies.
your control.
Yeah. And you got to do them right away because if you knew about it like 6 months ago and you didn't put it in,
Yeah.
then it's not
Well, or upon the
valid.
first meeting with the lawyer, and then you guys hemmed and hawed, or we did, or
Mhm.
you did, or you forgot to tell your attorney, "Oh, I had this. By the way, I got this RVR a week before I met you," and then you tell me at the next meeting.
Mhm.
That can be tricky. That can be trickier, but
Yeah.
very, very hard for attorneys to get postponements on behalf of their clients. It's just very
Mhm.
hard. That doesn't
Exactly.
do anything other than remove your option of the 6, 7, 8, 9, 10, or 11-month option. So you
Yeah.
still have the waiver option, but that has a time frame. So postponements do not have to be made at least 45 days before the hearing, but they do have to be made upon the first notice to you that there's some beyond your control issue.
Mhm.
Waivers must be made before 45 days, and if they are, any good reason. So let's talk about that. You can get a waiver for 1, 2, 3, 4, 5 years.
Correct.
You wanted to add something?
Yes, you can only waive the hearing 3 times without having to go to a hearing.
So only 3 times. And
Mhm.
so what are some reasons why we counsel clients to waive hearings?
Well, like you said, we got to put it in 45 days at least before the hearing, but some reasons are, they want to finish up a program, uh, they want a little bit more discipline-free time between the discipline and the date of the hearing. Those are I think, two of the most biggest reasons. But you can
Yeah,
waive for almost any reason at all, and it'll be valid as long as it's at least 45 days before the hearing.
yeah, if he doesn't really have a really good reason. So I need more time to prepare. The only reason I don't love that, and I have used that in the past, if I have a difficult client that's just not doesn't really know why, doesn't agree that he needs more of this or more of that or whatever. It's very rare, but or
Hmm.
if I've been given a bad time for the reason I put down. But I do try to put a thorough reason
Hmm.
so that number one, Sacramento knows that I have properly counseled the client on things, but also the next attorney will see it on the form as to, what we were going off of. Why
Hmm.
did this happen? Because you don't get a lot more. You're not going to have a transcript on most occasions, and you're not going to really understand this except from your client's point of view, your loved one's point of view, and sometimes their point of view, uh, you know, they forget or they thought it was one way or they misapprehended the situation like we all can do. But uh, the attorney then has that comprehensive notation in the file on that decision form as to what we sort of were contemplating. So a recent RVR is definitely it's an interesting reason to waive, but it may it's harder to figure out how many years then to waive on that. And then another reason, you sit down with them and they've already got an old risk assessment. Say a risk assessment's like, it's going to be 2 years, 9 months old at the time of your hearing, or and some things still aren't quite right with your program, with your rehabilitation efforts. So that year may bump you to get you to a point where you could get a brand new risk assessment with a great rating. So you've got a moderate, higher and a moderate, and you've done, with a little bit extra work, you could probably waltz in and walk out with a low risk, which is putting you in the end zone, in closer to the end zone, whatever.
Yeah, it's setting you up for a good hearing if you have a low.
Setting you up for a much better than a moderate or high, obviously. So you've got that opportunity. If there's something that hasn't been addressed, I like waivers for your discipline-free record is great, but you're missing this one key thing, that the commissioners are not going to grant you parole if you don't have it. And you can say, well, say you don't have domestic violence and your crime is something of domestic violence. You have, oh, well, I can just quickly take prep and get the box checked. But if your crime, life crime, not just some misdemeanor way back before the life crime, where you're going to need to have some protective factor there for it, but it's actually the essence of your crime, a correspondence class done 4 months before your hearing is unlikely to cut it. And what the commissioners call it sufficient dosage. Dosage meaning, and
I've
they
heard
say
that.
sufficient dosage. There's some other expressions used, and it's not just a 20-hour one and done, I check the box. It's going to have to be contemplation of a substantial period of time, which could be that year, but probably won't be enough for that 4 months if you just said, I just took domestic violence and your life crime involves you murdering your spouse. Sorry to say something negative, but if that's the crime, that's a good reason to waive and get that under your belt, because in that year, you have a good opportunity to be found suitable, and you're not just waiving to add time to an ultimate denial in the year. What do I mean by that? You've got a cell phone 6 months before meeting with your attorney, and your attorney's like, look, we're looking for 3 to 5 years clean between these write-ups, depending on your history of write-ups. Okay, so if you've got a history, one after another of write-up after write-up after write-up, and then you got another one, and the last panel not told you not to get one, and this happened and that happened, whatever, you could be looking at a 5-year denial if you walk into that hearing with that kind of history. Now, if you've been a model inmate, you picked up a cell phone because your grandma died and you were frantic and you just needed to reach out, no one was accepting your collect calls and whatever, they're going to give you more of a pass. I don't know what a pass. They're not going to give you a total pass, because they are going to require some distance so you can work on your relapse prevention planning for that type of behavior. What is the behavior? Criminal thinking, back to your impulsivity, antisocial personality disorder coming up to rear its ugly head, not thinking of consequences, all the stuff that plays into that. You may be able to get a grant of parole in a 2.5-year clean, 3-year clean. Some of these commissioners are 3 years to the day kind of thing. So that year is not going to get you where you need to be. So next year, you're still only going to have a 1.5 year clean. The next panel is going to, nice, good work, still not there, 3-year denial. Okay, depending on what happens. So you might want to not waive for 1 year. You might want to waive for longer, or you may want to stipulate and work your way back from there. So go to your hearing, stipulate, say, I know I'm unsuitable because I don't have that lengthy period of positive rehabilitation that you've been looking for. I know I need that. That shows a lot of responsibility, a lot of accountability, so that in a year and a half, you could come in, petition to advance. You've now got 2.5 years clean for the cell phone, and you take that chance and you see if you can get that parole grant. And that's what I was saying at the beginning of this with the matrix. You've got to kind of look at what gets you out the door. So if you waive the next year, you're going to probably be denied because it's just not enough clean time. So now you have another 3 years to stack on that. You might end up getting an admin review, but now you're coming out the door in 2.5 years plus the review process, right? So you really have to think about these things. Or maybe you wait for 2 years, maybe it's trickier, and you come back and now you have 2.5 years clean. And your goal is to really hammer your program out to try and get that grant of parole in that 2.5 years. Okay, because I don't think that enough attorneys think about these year waivers and what they're doing. They're saying, just waive for a year and then come back. I said, but that year hasn't done anything for you. You're still not going to be found suitable because this is missing, this is missing, this is missing. So you really have to do that. You really need to think about it from that aspect before you just say, well, you have an RVR, so you better wait for a year. No, not the right analysis. You have to think beyond that. So I like to use waivers when there's a missing program. Sex crimes require road to freedom or whatever. You need, that book is thick, it's dense, it's needs a lot of thought. You need to spend a lot of time on that 300 plus page book.
Yes.
You can't do that book in 4 months and be found suitable for parole most of the time. Not to mention, you just can't finish it. But even if you finished it, you're not going to have it internalized to the point where you can really have a good conversation with the panel about that book. You need that year, and you're discipline free. You're the kind of guy that year you're expecting to come in next year then and knock it out of the park. You've put yourself in the end zone. It should just be a matter of having the hearing, explaining what you've learned, going through your insight and all of that, and be out the door. And then, lack of programming, too many RVRs. And then there's the ability to articulate it. You've got the programming, got a clean record, but something's just, you haven't been able to connect the dots. So
there you go.
Another year to really help you figure out how you could connect the dots better and articulate yourself so the panel thinks that you really understand your causative factors, which is a fancy way of saying character defects, triggers, victim impact, all of it.
Yes.
Well, not victim impact. Victim impact is different, but causative factors, character defects, triggers for your behavior, childhood trauma, etc. And connecting the dots between that and the behavior, because what happens to our clients and they get in there and go, well, why'd the crime occur? Well, I had my dad was bad and my mom was bad. And I go, no, that's not why the crime occurred. That's not why the crime. That's why you got your character, how you came to have these character defects, but that's not why the crime occurred. And so you just need some help with the narrative up until that point. But these are some reasons for waivers, but waivers have to be done very carefully, because otherwise what you're doing is you're just adding an extra year onto a denial. So you're going to be denied the next year for 3 or 5 years. Now you've really just given yourself a 4 or 6 year denial in essence. Very tricky. Very good to have a very good lawyer behind you that can sit down and flow chart this with you to see what gets me. Remember, rule of thumb, number 1, Rule number one, what gets me home soonest? Not my family says I want to have my hearing, but what gets me home the soonest? And maybe it is. Maybe you do need your hearing. Maybe you should just go to that hearing because the waiver is just simply adding time. And maybe
Mm-hmm.
you need to go to the hearing, come away with a denial, and work back from there. The only problem with that is if you get stuck with a 5-year denial and you're not someone you think, you're not a person, or your loved one isn't a person you think could sort of keep his behavior within the rules without slipping up, that can cost him the entire 5 years and ruin his chances to get a petition to advance. So there's risk there,
Yes.
which means you could come to the hearing then, and maybe you should just stipulate to unsuitability for 3 years if the
Mm-hmm.
panel will give it to you in light of a recent write-up or a poor CRA or something like that. Most of the time they will, because they want to move on to the next hearing. Some
Correct.
commissioners will not if they just think it's a 5. But if they don't, then fine, go to your hearing. A 7
Yeah.
or a 7 or a 5 is the same thing. And then if they end up giving you the 3 anyway, then fine. But
Correct. And with a stipulation, you're saying, I'm not ready today, but I'll be ready in 3 years or 5, 7, 10, 15, whatever the term,
that's right.
whatever the term is that you were able to negotiate. But usually, like you said, usually it's you can get a 3 because they want to move on. And believe me, when there's 3 hearings and that's the third one of the day, they're
You want a 3? We'll give you a 3, even
sure.
though you're looking at a
Exactly.
10, but we'll give you a 3.
Exactly. And then they say to the DA, would you like to have any input? Oh yeah, well, you know what, we really want a 5, but we'll go with the 3 today.
We'll take the 3 too because we want to go home. But
Yeah.
yeah, the
Mm-hmm.
stipulations as well. I always tell my clients a waiver is just, "Well, I don't want to waive my rights." I said, think about it this way. Just think
Mm-hmm.
about the waiver as just a kind of a word that's not the best word. It's just telling the panel, I need more time to prepare. I don't want to waive
Yes.
because I don't want to tell them I'm unsuitable. You're not telling them you're
Mm-hmm.
unsuitable. You're telling them, I need more time to get ready so that I can be found suitable.
Mm-hmm. And you're
Versus
taking accountability too.
you're still taking accountability. And then a stipulation is saying, I know that I would be found unsuitable today. And thus, I'm going to just stipulate without the need for the full hearing to get to that ultimate finding. And I'll
Mm-hmm.
see you back here in 3 years or less, or 5. Sometimes if you have a guy that's looking at a 10, a 5 is good.
Mm-hmm.
It's really
Yeah.
good. It's half because you have those. And that can work out too. Whereas a waiver just isn't going to cut it. The other thing about waivers is you cannot change your mind. You cannot petition to advance. You can't do anything. You're stuck
Yes.
with the year that you chose, or the 2 years that you chose, or the 3 years that you chose. I just had a guy tell me that he wasn't going to do anything less than 5-year waiver. He doesn't want to go to his board of parole hearings at all. He's got a determinate sentence and he wanted to just do his time. He didn't want to do the work.
I
He
had a guy
wanted,
exactly like that. Yeah.
yeah, he doesn't want it. He said, I don't want to do their process. I just want to be in prison. I'll do my time.
Mm-hmm.
I'm not going to put the effort in. So why bother?
Yeah.
I said, okay. And we went through it though. I went through the 1, the 2. I said, I really don't like this because you can't change your mind. He goes, I know. I hear
Exactly.
you.
Mm-hmm.
And so I signed off on it. And because
Same
I
here.
have to, after I've counseled him fully and he's fully aware of the risks involved and the rights to not petitioning to advance, he's got to do that. So
Yeah, you got to
um,
spell all that out,
you
But
have to. And then with these year waivers, like say the year is just putting him into, he's still going to be denied next year. You
mm-hmm.
can go through that discussion, but sometimes if I have a mentally unstable person or someone with a learning disability or someone who procrastinates or is unmotivated or they're just kind of down in the moment. Sometimes you can do the year, even though it's not really getting you next year any closer to a grant of parole. At that point, like, you're not going to be found suitable. You can say, look, but at least it gives you another chance to talk to a lawyer, and then you can gauge where you're at to see how much progress you've made. So sometimes that if you waive for 2 years, then you don't see a lawyer for a while, and then people get off track, and,
Mhm.
the yard and the this and the that. And then if you have that visit again, it's like, oh yeah, okay, I gotta get serious about this. And then sometimes all this stuff, even if you're not ready, even if you're missing programs, even if you have a recent write-up, sometimes if you've been someone who's just been stipping, or it's been postponing, or it's just going on and on and on, sometimes you just have to go in there and do
Mhm.
the hearing, because it
Exactly.
can be that turning point for a lot of clients. They don't realize it. And if you see, like, for attorneys, or if you see your loved one just putting it off and putting it off and putting it off, it might be just time to go in and bite the bullet and say, because,
Exactly, like, because I've seen it doesn't happen very often, but somebody who hasn't been to a hearing in, like, in 10 or 15
oh
years,
my God.
and it's about time that they went, and it's like a wake-up call for them when they get slapped in the face.
Yeah. Or it's just that other figure, that other perspective from the
Mhm.
actual commissioners, because we'll get a lot of clients saying, well, I want to hear what they have to say.
Yeah.
And
Oh,
of
yeah.
course, you and I sit there going, we've been telling you what they want to say. Joe's been doing this for 15 years, I guess, and me 10. So they don't believe us. So, and then
Yeah.
you have the clients that don't believe us at all about, well, I'll be able to explain why I got that 115
Oh,
last week,
yeah.
and it'll be fine.
Yeah,
And
sure.
and I'm a nonviolent offender, so it'll be fine, and I should be able, yeah, okay.
Yeah,
Yeah.
yeah, and plus I haven't had any violent write-ups in 15 years, blah, blah, blah.
It's not a violent write-up, so it should be fine.
Yeah,
All right. That's
exactly.
kind of, yeah, that's how that goes. But
Right.
these are the options.
Mhm.
This is what we're there to try and help navigate, primarily, as to, how are we going to proceed in the light of your record? How do you feel? Do you want to go forward? And then if not, which one of these vehicles is the best one? Obviously, continuance doesn't apply.
Right.
Most of the time, a postponement doesn't apply. So are we going to do a waiver, or should we do a stip? Another reason I like waiver is if someone needs a new risk assessment and they just got a write up, or they don't have a particular program, or they haven't connected the dots, I can zip that in there before the psychologist has come out, and avoid a potentially higher aggravated risk assessment than we would have got if we just get that one more year that could really turn the corner in terms of how they present and how they walk out the door with maybe a moderate, lower end of moderate, low risk assessment, rather than going in and getting stuck with that risk assessment for 3 years.
One exception to that is, and this gets really frustrating, not only for me, but for the client themselves, is when they put it off a year to get a new risk assessment, but then, the waiver's granted, then they get a ducat, they go in, and it's the psychologist doing the review after they waive. That's happened
So
before.
once that happens, you write FAD immediately, and you tell them that he's entitled to a new one. That it's a 50-50. But one thing that I do when I send that waiver up there, I sign it on behalf of the client. I tell them why I think it's important for me to sign it on his behalf, and I scan it I CC FAD, and I say, cancel the appointment for the risk assessment.
You know what? Thank you. That makes total sense.
Yeah, because they don't know. The what one hand doesn't know the other, what the other hand, they forget to tell the evaluator. She doesn't know. Then the client's up against the situation where he's got to refuse, or he's got to try and go through it when the attorney's already advised him that we want to get better prepared. And that's another reason for a waiver. I want to get better prepared for this meeting coming up. I want to address the concern, the recommendations given to me by the deputy commissioner during the consultation hearing that I have. I want to address the risk factors from the old risk assessment. I want to do, you can do sometimes that way as well, but it's mandatory. Any family members out there, you tell your clients to tell any attorney representing him or her that the attorney needs to CC FAD to make sure, at least try. And sometimes it still slips through the cracks, but believe me, the psychologists want to get one off their calendar. They don't want to, they're not like, oh, I want to race out there. I want to definitely have the meeting with this guy. They don't care.
Right.
They've been assigned 90 more people.
Exactly.
So they can get on to
it's like
the next
the
one.
commissioners agreeing to a 3-year stipulation.
They don't want to interview your guy. I mean, they want it if they're assigned, but if it's one less, okay, fine. They can put another one in there.
Exactly.
And that helps with backlog and stuff. So really important. And then you can fight that after. And the other issue is the psychs coming before the attorney comes out to even visit. If it's within that 30 days of appointment, that can be an issue. Really hard. I've tried to argue that issue and I get denied, but do the best you can. And there's always ways to mitigate that risk assessment. But these are vehicles that you can use to think about how your loved one, think about it now in terms of how does he get out the door sooner, not how does he get to his hearing sooner.
Exactly. That's very well put. Very succinct. Exactly.
Yeah. All right. Any final thoughts on any of that?
Well, just in general, I would say listen to your attorney. If they're trying to tell you to waive the hearing or put it off or stipulate and listen to the reasons why. And if it makes sense, then think about going with that attorney's advice. That's kind of my final word.
Yeah. And make sure, if you possibly can, that the attorney is taking the time to go through everything that you need to have ready for that next year. Otherwise, it's just a waste.
Exactly.
An attorney that just comes in, oh, you got a recent 115, you need a waive. Okay, here, sign here. That's not what you need.
That's almost malpractice, because you should give them instructions for what they should be doing in the next year while they waived it. And if they don't follow you, well, that's their problem, but you let them know.
And that's why I write it all out. So I go through their entire rap sheet and we make sure that we've covered all the risk factors. Is there this random domestic violence thing that happened that you got a misdemeanor for? Believe you me, even if your crime is carjacking, you're not going home until you have domestic violence and a domestic violence relapse prevention plan. And you've got some statutory rape from whatever. You might not be going home unless you read The Road to Freedom.
Exactly.
Even though, it was consensual sex between you and your girlfriend or boyfriend or whatever. So just, you need to go through that entire risk assessment or rap sheet, probation officer's report, and find all of your risk factors, whatever it is. Criminal thinking. Do you have an anger management problem? Do you have a mental health issue? Do you have this? And really write out all the risk factors for them. Really go through the programming requirements, the things that commissioners are going to say.
Yeah.
At your hearing. Oh, you have that program? Good. Oh, you don't have that program? Oh, well, that's something that the attorney should have mentioned. Now, do we miss things? Yes, but that comprehensive meeting, not a 15-minute, oh, good, you got a waiver, you got a RVR, let's waive. So I'm not saying the attorneys on our panel do that, but anyway, it's something to look out for.
Yes, exactly. All right.
Excellent topic, Joe. Excellent topic. I know you're excited to get back to all your Sunday activities. I've already finished all my en banc stuff. Now that I looked at this other letter, I think I might make some revisions based on our discussions earlier. And then
Okay.
next week, I think you mentioned a great topic was stress management before your hearing,
Oh,
how to
yeah.
handle all the various noise that's coming your way, probably as well for that. And so with that, I guess anybody who wants to like and subscribe would be appreciated. Although my intentions is not for that. This is just a tool for family members to rely on, a resource for them to rely on for my clients and for Joe's clients and anybody else who happens to get this notice of this live stream. So yeah, please feel free, Joe, to let your clients know that their families can find this as a resource to help understand the parole process.
I will. Absolutely. And how can they can subscribe to you on YouTube, correct?
Yeah, they can subscribe to you and I, Light on Suitability, and they can find any resource they need. Well, if you're tuning in now, they already know, but Light on Suitability. Light on Suitability is my website. Joe, where can they find you if they want to give you a call? You've got a book. I always forget to mention, Joe has written a book. He's got a second edition. It's called 52 Ways of Suitability.
36 Strategies of Suitability.
Sorry, I knew that.
That's
36
okay.
Strategies. He's got a second edition. It's an excellent resource. A lot of my clients use that book as a guidebook for them. Comprehensive.
It's all about navigating the parole suitability process.
Yes, all about it. And
if they need to contact me, my information is in the back of the book. I'm in.
Oh, beautiful.
I also, my email is jrhaytas@haytaslaw.com. My website is prisoneradvocate.org.
Oh, wow.
You know,
I did not know that.
I have to update though my
advocate
right
.org.
Yeah, I have to update the website. However, it's old, but it's one of the many things on my to-do list.
Okay. Well, you can hire people to do that for you.
Yes.
Upwork.com. You can put out a request for bids to upgrade.
Okay.
Yeah. And then you just give them the content. But yeah, there it is. I should share the screen of your screen, but there he is.
We can do it next week.
It loads a little slow, but that's just also something that can be tweaked by a person with experience fixing that.
Okay.
Okay. Thank you so much, Joe. I love coming on here with you. You're a great co-host.
Thank you.
And
I love doing this too.
Okay, good. I'll see you next week.
All right. Very good. All right, Elizabeth. Thank you.